Learning with Dr. Shivangi. Today's topic is statutory provisions of lifting the corporate veil. As in the previous videos, we already started the playlist for the subject companies law and also discusses various topics related to it like meaning of company, limited liability company, liability partnership, different provisions of company, administration of company, and so on. So in today's video we'll discuss about the statutory provisions of lifting the corporate veil. You can also watch other videos, links are provided in the description box. So before I started the video, I want to say you that if you like my video, please like and share this video, and don't forget to subscribe my channel, which is Learning with Dr. Shivangi. Now coming to the main topic, which is statutory provisions of lifting the corporate veil. Firstly, we have to understand about the corporate veil, or what is the meaning of lifting the corporate veil. As the company has the separate legal entity, it is not binded with the members of the company. All the functions are performed by the board of directors of the company. So board of directors are liable for the functions of the company or acts of the company. So it is known as the corporate veil or lifting the corporate veil. Now coming to the statutory provisions. What are the statutory provisions of corporate veil? The Indian Companies Act 1956 defines the express conditions under which the corporate veil may be lifted from the company. These conditions are as under, which are: first one is reduction of the number of members below statutory limits. Second is establishing the relationship of holding and subsidiary company. Third is investigating the affairs of the company. Fourth is investigating fraudulent trading. Fifth is non-disclosure of company's name. Sixth is investigating company's name. Seventh is non-return of application money. And the last is misstatement in prospectus. So these are the different statutory conditions of lifting the corporate veil of the Indian companies. Now we are discuss here each of the points, each of the conditions one by one in detail. So first one is the reduction of the number of members below the statutory limits. If at any time the number of members in a public company is reduced to less than 7, or it is reduced to less than 2 in a private company, the company carries on its business for more than 6 months. Every individual member of the company who is aware of this fact shall be individually liable for the total debts of the company and can be used for the realization of such debts. So this condition is defined under section 45. So if the number of members are goes below the prescribed number of the members, so in this case each individual member in the case of public company as well as the private company are responsible for this type of act and also responsible for all the debts of the company itself. It is important to note that under this section, while the company continues to be liable for its debts, with the lifting of corporate veil, its members become individually and severally liable for the company's debts, even if their liability is limited. So when the members goes down, on the number of members goes below the prescribed limit, then all the members are liable for the acts of the companies. The second condition is establishing the relationship of holding and subsidiary company. When the management of the one company is controlled by another, the company controlling the management is called the holding company, and the one whose management is controlled is called the subsidiary company. The subsidiary company retains its separate entity, and the holding company cannot be held liable for the decisions, for the actions of the subsidiary company merely because it has originated the subsidiary and has control on its management. So in the case where there is a provisions of holding company and the subsidiary company, where holding company is the main company and the controlled company is subsidiary company. In this case, the subsidiary company has its own separate entity and the holding company is not liable for the actions of subsidiary company. The subsidiary company cannot be deemed to be inheritance or property of the holding company. The law provides that the corporate veil may be lifted to determine whether there exists a relationship of a holding and a subsidiary company between the two. So when there is in the case of holding and subsidiary company, holding company is not liable for the acts or function of the subsidiary company. They are not interlinked with each other. With the objective, section 212 provides that every holding company shall attach to its balance sheet a copy of balance sheet of its subsidiary company, a copy of its profit and loss account, a copy of report of its boards of directors, and a copy of reports of its auditors. When in particular circumstances, when it is responsible for the subsidiary company, holding company has to attach all the documents like balance sheet, profit and loss account, reports of boards of directors and reports of auditors also with the balance sheet of the holding company itself. So this is the second condition of the lifting of corporate veil. Now coming to the third condition, which is investigating the affairs of the company. If the management of the company is not satisfactory or it is following fraudulent and oppressive policies towards some of all its members, the inspector appointed to investigate the affairs of the company is empowered by law to investigate the affairs of any other related company or companies under the same management or group. The corporate veil or legal facade may be lifted to ascertain which company or companies are being managed by the holder company. So if the management is not satisfied with the fraudulent case or oppressive policies of the members, or in this case the inspector appointed by the holding company for the subsidiary company, in this case the corporate veil can be lifted. The next condition of lifting the corporate veil is investigating fraudulent trading. If in the course of winding up of company, it is revealed that the company has been carrying on its business with the intent to defraud its creditors or any other persons or for any fraudulent purpose, the court may set aside the legal corporate veil of the company and hold the persons responsible for the fraudulent activities personally liable for the debts and liabilities of the company. So when the person involved or board of directors involved in any fraudulent activity of the company, they are responsible for the acts or functions of the company by the code. The next condition of lifting the corporate veil is non-disclosure of company's name. It is defined under section 147. If the name of the company and the address of its registered office has not been properly and clearly written or affixed on any document or contract, the person actually responsible for such act shall be personally liable for the consequences of such act even if the contract is in the name of the company. For example, if a company's functionary signs a promissory note on behalf of the company without clearly affixing the company's name on it, he shall be held personally responsible for the promissory note. So, in this case, when the company is not disclosed its name or fixed in the document or contract, then the person is responsible for such act of the company. So, it is also the condition for the lifting of corporate veil. The next is investigating company's name. Under section 247, the central government may appoint one or more inspectors to investigate who are the persons who actually control or materially influence the policy of the company. So for investigating the company's name, central government may appoint any other person who is known as inspector to investigate the person's functioning who is responsible for the functions of the company. The next condition for lifting the corporate veil is non-return of application money, which is defined under section 69(5). One liability of the company is that it must forthwith return all money received from applicants of shares who are not allotted the shares they had applied for. In any such case, money is not repaid within 130 days of issue of this prospectus to applicants who have not been allotted any shares, the directors of the company shall be individually and severally held liable. When the money is received by applicants of shares are not allotted the shares, so it can be repaid within 130 days of issue, returned according to the prospectus of the company. The last condition of the lifting the corporate veil is misstatement in prospectus under section 62. If there is a misstatement in the prospectus of a company inviting the public to subscribe for shares or debentures, then every director, promoter, or the person who has issued the prospectus is personally held liable. So in the case of misstatement of prospectus of the company in the public or private companies, director, promoter, and the person who issues the prospectus is liable for this act. So these are the different conditions for lifting the corporate veil. I again summarizes all the points so that you can easily understand about the topic. So the first condition for lifting the corporate veil is reduction of number of members below statutory limits. When the number goes down in the case of public company below 7 and in the case of private company below 2, the person, each of every member is responsible for this act or any functions performed by the company or the debts of the company itself. The next condition is establishing the relationship of holding and subsidiary company. Generally, holding company is not responsible for the subsidiary company, but some actions are responsible. Some actions of a subsidiary company, holding company is responsible. Like it is not the deemed property of the holding company. The holding company must maintain the document of its subsidiary company like balance sheet of subsidiary, profit and loss account, report of boards of directors and report of its auditors. The next condition is investigating the affairs of the company. The investigation is done for checking the functions of the company for board of directors or the management of the companies itself by the government of India. The next condition is investigating fraudulent trading. If any person belongs to the company involved in the fraudulent trading, it is also responsible for the functions of the company itself. The next condition is non-disclosure of company's name under section 147. When the person is not disclose the company's name, he is liable for this act. The next condition is investigating company's name. The central government may appoint any inspectors to investigate the person who is actually control the functions of the company. The next condition is non-return of application money. It is the function of the company to return the shareholders its money. If any person not return its money, he can claim his money within the 130 days of issue of prospectus of applicants. And the last condition of the lifting the corporate veil is misstatement is prospectus. The person who prepared the prospectus or the directors or promoters all are responsible for such act of misstatement of prospectus in the companies. So these are the different conditions of lifting the corporate veil under statutory conditions. If you have any query about this topic or if you want to know about any topic related to research methodology, business management, companies law, you can ask me through comment box. If you like my video, please like and share this video and don't forget to subscribe my channel, which is Learning with Dr. Shivangi. We'll meet in the next video with new topic. Thank you everyone.